The order to allow for a termination or modification of a guardian of a minor, guardian of an adult, or a conservator. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover a particular and very versatile scale form called scale PC638A. PC for probate court. SCAO stands for State Court Administrative Office. This is the court form used following a hearing on a petition to either modify a guardian or conservatorship or to terminate a guardianship and conservatorship. So when I use the term versatile, I meant that it is used for a variety of proceedings at the probate court. As you can see from the top, there are various check boxes that you can utilize to identify whether this involves a guardian of a minor, a guardian for an LII, which is an adult, or a conservator. In the bottom left corner, you'll notice that the yellow arrow is pointing at a variety of statutes and court rules. These statutes and court rules are governed by EPIC, E-P-I-C, the Estates and Protected Individual Code, and there's a lot of statutes and court rules that govern this particular form because it is so versatile and is used in so many different proceedings. We always urge you to work with a skilled, competent probate practitioner when navigating through the probate court. These are not easy things to do, they're not always intuitive, and of course having a skilled, competent probate lawyer will allow them to be able to guide you through the process and understand the statutes and court rules that are in effect. Let's work our way through the document. At the top left corner is the county of venue, and then the top right corner is the case number and the judge's information. The court address is reflected there, and then in the matter of is the name of the person that this document is effective for. Now this doesn't apply for deceased estates. Is only for those people that are alive in the form of a guardianship and conservatorship. Remember, guardianship to guard over an individual, conservatorship to conserve assets. I've done many videos explaining the petition for the appointment of a guardian and conservator. You can look through our database for those instructions as well as the forms. As you work your way through the document, these are the findings of the court. One is the notice of hearing as required by the court rule MCR 5.125, and that it identifies whether you're asking the court in paragraph 2 to either terminate, modify a guardianship, conservatorship, or maybe it's both, and whether it's granted, denied, or dismissed. The second checkbox is that the court can, on its own motion, meaning without the request of somebody filing a petition, modify or terminate the guardianship or conservatorship. Now, the second part is that the fiduciary should be removed and a successor appointed, or various things that the court can do rather than filling it in and writing it in. The court can use these very convenient check boxes to identify whether, for example, there needs to be a guardian in place, whether the minor needs to continue to have a guardian, etc. So again, it's a very versatile form that can be used in a quick form for the judges following a court hearing. In addition, number 5 identifies a very particular case in which there's no suitable family member or individual to serve in that role, and there's a professional fiduciary that's going to get appointed, professional guardian or conservator. And then in 6, whether a co-guardian is necessary. The next part identifies the court order. So first, above are the findings, and then kind of a repeat here in the court's orders, and again whether it should be granted, denied on the merits, or dismissed, withdrawn, and then who is permitted to either resign or be removed in paragraph 9. On the second page of the document, it continues and identifies who is getting appointed as the fiduciary. And then again, a lot of opportunities for the court to have variations here for the appointment of a full guardian with full expansive authority, a limited guardian with certain powers, a temporary guardian for a particular period of time, and whether a surety bond is required. A bond is a guarantee of the performance of that guardian. Now, an important sentence at the bottom of this red rectangle, it says a guardian is not permitted to act until the letters are issued. So the reason for this is that the court may enter an order, but if there's a bond, for example, or any prerequisites before the authority can occur, the person has no legal authority to act until such time as they fulfill the conditions precedent, for example, the obtaining of a surety bond. So after qualification, the guardian then is required to follow Michigan law, but they can't act just simply by virtue of this court order. The next part talks about guardianships of a minor child, very similar language that we saw above, but rather than for an adult, it is particular for a guardianship of a minor. On the third page, it again identifies a space for the court to add modifications or additional information about modifications that may be existing within that guardianship. And then whether there's an attorney that has been appointed in the proceeding or a guardian ad litem, whether that individual is discharged. Now, the reason that there may be a guardian ad litem or an attorney appointed for the individual is the statutes give rise to various protections for the person that is being sought guardianship over or is requesting a termination. So that person has a right in certain circumstances to either the appointment of a guardian ad litem to be the eyes and ears of the court, or the appointment of a court-appointed attorney to ensure that their rights are protected because they are vulnerable individuals. Paragraph 14 identifies whether the matter, the proceeding, is closed or not closed, and this really directs the court to keep the file active and open or to close it. As we work our way to the bottom of the document, there's a spot for the judge's signature, and then if there's an attorney involved, for the attorney's information who helped create this particular order. There's a lot going on here with this order, and again, it really is a form that's often completed by the courts, but not necessarily, but it follows the petition, which is the request of the court for the actions that are being sought within this court order. At the Probate Pro, we're passionate about everything probate. If you have questions about this order or any probate-related issue, visit us at theprobatepro.com or call us at 1-833-PROBATE.